In our continuation, looking at the various different kinds of relationships within family law, I want to just carry on focusing on the issue of marriage in a little bit more detail, and then sort of look at the idea of forced marriage. Now, obviously, the idea of a forced marriage, somebody being forced to enter into a marriage relationship, is obviously quite a significant human rights violation. So the sort of beginning and ending of what the law says about that could be sort of done and tied up right now. But I do want to go into it in a bit more detail and focus on the ways in which there are legal protections against forced marriages. So that's what this lesson will be. This lesson will look at the legal protections against forced marriage, as well as the various remedies which are applicable for victims of forced marriages. The first question is then, how do we define forced marriage? What is a forced marriage in law? And like I said, how is that defined as a concept? Well, as we noted in the previous lesson, a forced marriage is a marriage arrangement which takes place without the consent of the parties involved. Okay, this either be on the part of one of the parties or both of the parties involved, but someone has to not consent to the marriage. Okay, if you're going to make marriage to somebody, just a general rule of thumb, make sure that they consent to that arrangement. It may take place for a multitude of reasons. So, for example, it could be for cultural, traditional reasons. There are some still cultural reasons that still values individuals in marriage. There might also be economic incentives, as well as for the purposes of human trafficking. So, forced marriage is still quite a significant problem. Now, the key consideration that needs to be notified when we think about what makes a marriage an ordinary valid marriage versus what makes a marriage a forced marriage is the fact that there has to be voluntariness within the sort of process of marriage itself. A key consideration within the process of marriage is that they are entered into voluntarily by the people who want to get married, fundamentally. So, this hinges the validity of a marriage, fundamentally, in the sense that voluntariness is a requirement, or at least consent is a requirement for marriage on both parties who are entering into this particular relationship. And so the result of that means that any kind of marriage that is done without an individual's consent is a forced marriage and is therefore invalid. So, getting just the very basic, very easy, very straightforward, and really the common sense points about marriage, forced marriage, should I say, out of the way. How is the law able to protect individuals from forced marriage? Well, the domestic law itself has a number of key provisions which prohibits and protects victims of forced marriage. Firstly, forced marriage is a criminal offence. So somebody engaging in or causing or sort of soliciting a forced marriage is something that can incur criminal penalties. But there are also civil protections and civil liabilities that exist as well. And I want to highlight particularly the Forced Marriage Civil Protection Act from 2007. What this act does is apply a number of changes to the law, namely the protection of victims of forced marriage, in addition to the prevention of such marriages as well. So it sort of has a protection and prevention mechanism within its provisions. One thing that it does is inserts Section 63A into the 1996 Family Law Act. And what Section 63A of this provision now does is allow for the creation of protection orders in relation to the prevention of forced marriages. Marriages there spelt wrong, I apologise, at the end of that slide. So what do these forced marriage protection orders do? They're quite a significant part of the legislation now, incorporated by this particular act. Well, what the courts can do is have the discretion to issue protection orders for people who might be at risk of being forced into a particular marriage. Now, they will also have the effect of being applicable post-forced marriage as well. So once the act has been committed. So, for example, if a victim has already entered into a forced marriage or been forced into a marriage that they do not consent to, these protection orders can also protect them. A protection order usually relates to the maintenance of security of the victims. So, for example, they might make sure that they are forced to stay in the country and are not taken abroad for marriage. This is one of the major protections that they can essentially offer, because obviously taking somebody abroad to forcibly marry them is something that the UK's domestic legal system has a lot less control over. So if you can apply for a protection order prior to this thing taking place, prior to somebody going abroad to get married against their will, then this, of course, significantly reduces the ability for somebody to do such an act. And so these protection orders will help to secure the victims, and at the very least keep the victims in the United Kingdom, so that they can, so that there is a greater chance of protecting them against being forcibly entered into marriage arrangements. The police also have the authority to apply for forced marriage protection orders. This carries a criminal sentence if breached. And the criminal sanction is quite interesting as well. So Section 63C of the Family Law Act from 1996 makes it a criminal offence to breach a forced marriage protection order. So if a protection order has been put in place either by the courts, or if there is the imposition of a police forced marriage protection order, and if those protection orders are then breached, this can carry with it a significant criminal penalty. A breach of a forced marriage protection order can levy a sentence of upwards of 5 years in prison. So the maximum sentence penalty is 5 years.